The Supreme Court has ruled that the General Court-Martial has no jurisdiction to try civilians, declaring its involvement in such cases unconstitutional. The landmark decision delivered by the Chief Justice Alphonse Owini-Doro upholds a constitutional court ruling that had nullified military trials of civilians, dealing a blow to the government's long-standing position on the matter.
All charges or ongoing criminal trials or pending trials before the courts-martial involving civilians must immediately cease and be transferred. Order. I'm going to chase you out. So I said all charges or ongoing criminal trials or pending trials before the courts-martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. 3, this judgment, you just note, don't stop this clapping thing. This judgment shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law.
The ruling comes in response to an appeal by the Attorney General challenging the Constitutional Court's 2021 decision, which had declared sections 2119 and 179 of the Uganda People's Defence Forces Act unconstitutional. His Lordship Chief Justice ordered the executive and the parliament to reform the military court system, despite the court-martials being constitutional as the military courts.
The people of Uganda pronounced themselves in the course of the making of the 1995 Constitution, expressing their fervent desire to make a break from the ugly past that characterized life in our country, especially the grave abuse of human rights by the military. The Ugandan military has since been transformed into a professional force, and it has made remarkable contribution to ensuring regional peace, security, and stability. It is rather contradictory and rather disconcerting for a military force built on new and commendable professional dispensation to operate under the same legal framework that failed to check or avert military abuse of power with unspeakable ramifications. The 1995 Constitution provided the new wine, which the UPDF Act, as instead through the impugned provisions of the Act, sought to store in old wineskins, as it were. This is a blatant negation of the aspirations, desire, hope, and wishes of the people of Uganda, which the framers of the 1995 Constitution meticulously enshrined in no uncertain terms in the Constitution.
Justice Catherine of the Supreme Court declared a judgment suspending all the proceedings in the General Court-Martial, declaring the military tribunal's jurisdiction over the civilians unconstitutional.
I find Sections 1, Section 177, and Sections 1171G of the UPDA Act in its current form unconstitutional for enabling the surreptitious prosecution of civilians in military courts. For clarity, the above sections provide that every person found in unlawful possession of arms, ammunition, equipment ordinarily being the monopoly of the defense forces or to other classified stores as prescribed is liable to be prosecuted before a court-martial.
General Court-Martial is not a subordinate court within the meaning of Article 129(1)(d) of the 1995 Constitution. General Court-Martial and other military courts are disciplinary organs of the UPDF established under Article 210, whose jurisdiction is limited by Article 210B to handling matters related to discipline and removal of members of UPDF.
On the issue of remedies regarding matters pending before the General Court-Martial involving civilians, I would agree that they will be remitted to the civilian courts for consideration. And in regard to trial of members of the military, I agree with the recommendations given to the executive and parliament to work on the necessary amendments in order to bring the court-martial in conformity with the Constitution.
The Supreme Court, in its decision today, only 2 out of the 7 justices of the Supreme Court appeared to support the appeal. The justices that ruled to dismiss the approval were Alphonse Owini Doro, Catherine Elizabeth Musoke, Pasit Muhaisi, and Faith Mwanda. The 2 who ruled in support of the government's appeal were Mike Chibita and Monica Mugenyi. Story compiled by Rita Nandira for Church of Uganda, Family TV, News at 8.